When a 26-year-old political outsider took the mic, Justice Barrett tried to embarrass her. What happened next left the entire chamber in stunned silence. The walls inside the Dirksen Senate office building felt tight that morning, like they were holding their breath. Karoline Leavitt, 26, adjusted the collar of her dark green blazer as she stepped into the hearing room. The overhead lights weren't kind. They washed everything out: faces, nerves, even confidence. She walked past a few older staffers who barely glanced up. If they recognized her, they didn't show it. She took her seat at the witness table, across from the panel. Her hands rested neatly on a slim folder. No water bottle, no phone, no stack of notes. She wanted to look ready, not buried. At the far end sat Justice Amy Coney Barrett, stone-faced. She wasn't supposed to testify, not technically, but she'd been invited to observe and offer commentary during today's open session on digital privacy and constitutional boundaries in the age of surveillance. Karoline could feel the skepticism before anyone said a word. Most people in that room had a law degree from a top 3 school. Some had argued cases in front of the Supreme Court. She, meanwhile, had worked as a communications director, run a failed House campaign, and stirred the internet a few times. But no courtroom victories, no published legal essays, no academic citations, just conviction. Still, the silence said more than any resume ever could. She wasn't welcome. She was being tolerated. Senator Louise Geller, the committee chair from Oregon, leaned into her mic. "We'd now like to welcome our next witness, Miss Karoline Leavitt. Miss Leavitt, the floor is yours." Karoline looked up, straightened her back. "Thank you, Senator," she said, voice steady. "We're at a moment where the public's trust in our digital systems is eroding, fast. Americans don't know who owns their data, who watches them, or how long the government's fingerprints stay on their private lives. The Fourth Amendment has not kept pace with the Fourth Industrial Revolution." A few people shifted in their chairs. That line hit. She continued, "We've allowed surveillance to become routine. Legal justification for warrantless data collection has stretched beyond recognition. If our founding documents were living beings, they'd be wheezing by now." Someone behind her coughed to cover a chuckle. Even Geller blinked. Justice Barrett finally looked up. Karoline saw it, a flicker. It was small, but it was there. Still, the mood hadn't softened. Barrett spoke directly, her voice clipped and formal. "Miss Leavitt, can you clarify what legal precedent supports your claim that current government surveillance practices directly violate the Fourth Amendment?" Karoline didn't flinch. She didn't even glance down. "Yes, Your Honor," she said. "The Carpenter v. United States decision in 2018 established that individuals have a legitimate expectation of privacy in their cell site location information. The court ruled that accessing 7 days or more of that data without a warrant violates the Fourth Amendment." Barrett's expression didn't change. "But Carpenter applied specifically to location tracking. Are you asserting that the same standard applies to data gathered from search histories, app behavior, and third-party platforms?" Karoline met her eyes. "Yes, ma'am. That's exactly what I'm asserting. Because the principle in Carpenter was not about GPS. It was about reasonable expectations in the digital age. If our phones reveal where we sleep, eat, pray, protest, and vote, then so do our browsing habits. There's no moral or constitutional difference between tracking my steps and tracking my thoughts." A few heads turned. That wasn't in any law school outline. That was raw logic. And it hit hard. Barrett crossed one leg over the other, lips pressed tight. She was studying her now, not scolding, but still unconvinced. Karoline glanced at the rest of the panel. She could feel their curiosity starting to bubble up, but they weren't ready to admit it yet. Not in front of Barrett. The silence hung just long enough to get uncomfortable, but it wouldn't last. Because the next question Barrett asked wasn't just tough. It was loaded with a message, and everyone knew it. Justice Barrett leaned forward, folding her hands over a printed copy of Karoline's written testimony. She tapped the page lightly, as if dusting it off, and then spoke in a tone that was polite, but sharp enough to cut clean. "You mentioned the erosion of public trust in surveillance. Yet you cite no measurable harm, no specific injury. Can you explain how vague discomfort translates into constitutional violation?" There it was. Not just a question. An attempt to box her in. Barrett had been doing this for years. Discredit the foundation of your opponent's argument early, and you don't need to refute anything else. Most witnesses would stammer, scramble, or shift blame. Karoline didn't. She inhaled slowly, then responded, "Yes, Justice. I believe the measurable harm is the chilling effect. When people self-censor, when they alter their searches, silence their speech, or abandon protests because they know the government may be watching, that's harm." The Supreme Court acknowledged that in Lamont versus Postmaster General. The idea that surveillance must be physically damaging to be unconstitutional doesn't align with the court's own history. Barrett narrowed her eyes. "You're quoting a 1965 case about receiving communist literature in the mail. Do you believe that's relevant to cloud-based data in 2025? "I do," Karoline replied, her tone unfazed. "Because the fear wasn't about the literature, it was about the act of being watched. That fear is what suppresses speech. It was true in 1965. It's true now." Barrett paused, not because she agreed yet, but because she hadn't expected the reference. Most sitting attorneys wouldn't have gone there. Most wouldn't have remembered the name of that case, much less cited it under pressure. But Barrett wasn't finished. She tilted her head, voice firmer. "Let's try this. If you believe today's surveillance practices infringe on privacy rights, are you prepared to argue that national security tools like FISA warrants or metadata collection should be dismantled?" A subtle shift happened then. Karoline didn't hesitate. She didn't over-explain. She let the weight of her next words carry the argument. "I'm prepared to argue," she said, "that tools used in secret, with little oversight and no public accountability, are already doing long-term damage to democracy. We can't keep pretending that safety and liberty live on opposite ends of a seesaw." For a moment, nobody moved. Then Senator Charles Durham, seated 2 chairs down, leaned back with a low exhale. It was small, but it broke the silence. Barrett uncrossed her arms. "You're making sweeping statements without formal legal training. Do you consider yourself a constitutional scholar?" Karoline didn't smile. She didn't blink. "No, ma'am. I consider myself a citizen who read the Constitution cover to cover, asked questions no one wanted to answer, and didn't stop until I understood the answers." The line didn't just land, it stuck. Someone in the back row whispered to a colleague, and another staffer typed quickly, probably texting a journalist. The hearing was still being broadcast live across a handful of public service channels, but now someone was bound to clip this exchange and post it online. It was only a matter of time. Barrett pursed her lips. For the first time, she glanced down, not at Karoline, but at her own notes. It wasn't a retreat, but it was a recalibration, and the others sensed it too. Senator Geller raised an eyebrow slightly. Durham looked like he was half convinced already. A few aides scribbled faster. The tone in the room had shifted, but not because Karoline had won anything. She'd simply refused to back down. Barrett cleared her throat. "You've made bold claims, Miss Leavitt. We'll continue examining their substance. But I will say this." She paused, not to find her words, but to weigh them. "I appreciate that you came here without hiding behind notes." Karoline gave a small nod, the kind that said thank you, but I'm not done yet. But the most powerful moment was about to come, and it wouldn't be spoken by Barrett or even Karoline. It would come from something else entirely. The sound of a shoe shifting on the marble floor cut through the tension like a blade. Senator Hugo Marston, a quiet moderate from Idaho, leaned into his mic for the first time that morning. He was known for playing it safe, rarely jumping into ideological firestorms, but now he cleared his throat and looked at Karoline. "Miss Leavitt," he said, "I'd like you to explain how your argument applies to third-party data. If I hand my information to Google or Apple, haven't I surrendered my privacy voluntarily?" Karoline didn't miss a beat. "With respect, Senator," she said, "you didn't voluntarily give away anything. You clicked accept on a 20-page terms of service document you didn't write, couldn't negotiate, and probably never read. That's not consent. It's coercion in fine print." Several heads snapped up. A low murmur rolled through the back row of law clerks and aides. Even Geller lifted a hand to hush the room. Karoline continued, voice steady but louder now. "And the government's use of that data you didn't knowingly offer, removes the need for warrants. They don't have to kick down your door when they can just pull your history from a server in Mountain View." Barrett sat motionless, but her eyes were locked on Karoline now, no longer scanning the room, no longer drifting. She was listening. Karoline pressed forward, her voice calm but quick, like she was building a rhythm she didn't want to lose. In the Supreme Court's 1967 Katz decision, she said, the court held that the Fourth Amendment protects people, not places. And Justice Harlan's concurrence introduced the two-part test we still use today, a subjective expectation of privacy and an expectation society is prepared to recognize as reasonable. Barrett raised an eyebrow. She didn't interrupt. So here's the test, Your Honor, Karoline said. Do Americans have a subjective expectation that their doctor visits, dating history, religious beliefs, and political opinions won't be downloaded by federal agencies without a warrant? She let the question hang, then answered it herself. Of course they do, because privacy isn't just a legal theory, it's a part of dignity, of being human, and we've let that slip. Barrett tapped a pencil on her notepad, twice, then stopped. Your analysis assumes that third-party doctrine is outdated, she said, but precedent still supports it. Karoline nodded. Yes, ma'am, it does. But so did Plessy v. Ferguson, until it didn't. Courts change when conscience finally outweighs convenience. Barrett didn't answer. Not right away. Instead, she looked away, just for a second, toward the large seal of the United States behind Karoline. It was small, a flicker of thought, but noticeable. And in that moment, the rest of the room caught up. Not all of them agreed with Karoline. Some probably found her reckless, even arrogant. But they couldn't deny it anymore. She wasn't here for headlines. She knew the law. A man in the gallery stood and silently exited. His face was pale, like he'd just seen something he wasn't ready for. Barrett leaned back slightly. Let's test your theory, she said. Assume Congress passes a bill banning facial recognition use in public spaces. Would that conflict with prior decisions upholding surveillance in public areas? Karoline paused. Then, like someone flipping over a final card at the end of a poker hand, she replied, No, it wouldn't, because those decisions were written before surveillance became total. It's one thing to observe someone walking down a street. It's another to track that person, cross-reference their movements, match their expressions, and build a behavioral profile, all without consent. That's not public observation. That's automated stalking. Someone audibly gasped. Maybe a law student, maybe a clerk. But Barrett didn't correct her. She didn't call it exaggerated. She just looked down again. Thoughtful, measured, almost impressed. But the moment that truly tipped the room wasn't legal. It was personal, and it came next, out of nowhere. Senator Geller took the floor again, but her tone was more subdued now, as if the ground had shifted and she was trying to find her balance. Miss Leavitt, she began, you've been quite vocal about the dangers of unchecked surveillance. But some would argue that this paranoia is a symptom of generational distrust, that your age brings emotion, not reason, into a space that requires discipline. How do you respond to that? Karoline blinked once, as if the question didn't sting, but it did. She took a sip of water, then leaned toward the mic with something new in her tone. Not defiance, not performance, just clarity. I don't distrust the system because I'm young, she said. I distrust it because I've seen what happens when it operates in the dark. My generation didn't grow up reading about surveillance. We grew up being surveilled. A pause. She glanced down, then back up at the senators, the audience, and finally at Barrett. My high school library had cameras with facial recognition. My college kept track of our Wi-Fi logins and locations. Our phones, apps, even smart speakers. Everything is recording something. And the assumption is always that if you're not doing anything wrong, you have nothing to hide. She stopped for a breath. But the truth is, people hide things not because they're guilty, but because privacy is where dignity lives. You can't measure dignity in court documents, but you can feel when it's gone. Even Barrett looked away for a moment, just briefly. Karoline looked straight at her now. With respect, Justice, I've read your concurrence in the United States v. Wong case. In it, you defended metadata collection under national interest exceptions. But I also read your earlier opinion in State of Missouri v. Evers, where you warned against the overreach of government into private spheres. Those two rulings contradict each other. One protects the home, the other invites the state in through the back door. Barrett looked back at her sharply this time. Are you suggesting I contradicted myself? No, Karoline said quietly. I'm suggesting the court's evolving logic on privacy reflects how fast the ground beneath us is shifting. And if someone as sharp as you can be pulled in two directions, what chance does the average citizen have? There was no sound in the room for a full 3 seconds. Then Senator Marston said under his breath, "Wow," and forgot to mute his mic. Barrett didn't speak for a moment. She folded her hands, looked down, and then back at Karoline with an unreadable expression. Not anger, not frustration, just thought. "Miss Leavitt," she said slowly, "you mentioned that privacy is where dignity lives. Do you believe the law should reflect dignity, or only protect rights?" Karoline didn't hesitate. "I believe the law should protect people, and people need both. Rights without dignity are just paper, and dignity without rights is a promise no one intends to keep." The room felt heavier now, not because of tension, but weight. Real conversation, real risk. And Barrett, for all her sharpness, for all her experience, for all her titles, was no longer speaking from a mountaintop. She was in it with her now, equal footing. "I'll admit," Barrett said, "your interpretation of legal precedent isn't what I expected. You've been prepared." Karoline's voice softened. "I had to be." Another silence, and then it came from the back row. A voice, older, steady. It was Professor Devereaux, a retired law scholar who hadn't spoken publicly in years, but was known for watching these hearings from the gallery. "She's right," he said. "That contradiction in Wong and Evers has been ignored for too long." A few people turned toward him, stunned. Barrett froze, then blinked slowly. Karoline didn't smile. She didn't move, but her hands relaxed just slightly on the desk. But the real shift wasn't in what anyone said. It was in how people began listening. And in the silence that followed, the ground didn't shake. It settled. The mood in the chamber wasn't tense anymore. It was focused. Like everyone realized they'd stopped waiting for the moment to happen and were finally in it. Justice Barrett had gone quiet, not because she was finished, but because her next words suddenly carried more weight than she expected. For the first time in the hearing, she wasn't just reacting, she was reconsidering. Karoline sat still, not smug, not triumphant, just present. Barrett cleared her throat and adjusted her posture. "Miss Leavitt," she said, "I'd like to go back to Carpenter versus United States. You cited it earlier in support of your argument that surveillance of digital behavior should require a warrant. I'm curious how you reconcile that case with Smith v. Maryland, which upheld the third-party doctrine." The old guard in the room straightened. This was classic Barrett, pulling from deep precedent. And Smith v. Maryland was often a wall many privacy arguments broke against. Karoline didn't blink. "I reconcile them by looking at what's changed," she said. "In Smith, the phone company kept a record of one man's dialed numbers over a short period. Today, tech companies collect far more over much longer periods with much less transparency. It's not the same scale. It's not the same context. Precedent doesn't mean pretending the world hasn't moved." Barrett leaned back, pressing her fingers together beneath her chin. She said nothing. Karoline continued, "We treat the third-party doctrine like it was built for the digital age. It wasn't. It was written in a world where the most revealing thing you could do with a phone was dial it." A faint chuckle escaped from someone near the press table. Even Senator Geller, who had spent the first hour barely hiding her irritation, scratched the corner of her mouth to hide a smile. Barrett's voice dropped slightly, quieter now. "Miss Leavitt, are you aware that some scholars would argue that what you're suggesting, applying strict Fourth Amendment protection to non-physical data, could upend decades of established jurisprudence?" Karoline nodded slowly. "I am. But I also know that protecting old jurisprudence at the cost of human liberty isn't justice. It's nostalgia." That word hung in the air like the last note of a hymn. Barrett stared for a moment. Then, in a move that surprised everyone, she put her pencil down completely and folded her hands in front of her. "Let me ask you something, not as a justice, but as a person." Karoline waited. "What made you want to walk into this room and do this? You knew how it would look. You knew what people would say." Karoline looked around the chamber, at the rows of skeptical faces, at the officials, the aides, the cameras, recording everything, and then back at Barrett. "I didn't come here to be liked," she said. "I came here because too many people think the law is something that only belongs to the powerful. And if I didn't stand here today, someone else would have to do it tomorrow, and maybe they wouldn't be ready." That silence returned, But this time, it wasn't awkward. It was full. Barrett held her gaze for another beat, then offered a single, small nod. Nothing dramatic, just respect. The kind that didn't need to be explained. Professor Devereaux leaned over to whisper something to a nearby reporter, who immediately started typing. Senator Marston muttered, "This is going to be on every news outlet by tonight." Karoline didn't react. Her eyes were steady. Her hands still rested gently on that slim folder. She hadn't touched it once. Justice Barrett glanced at the panel, then back to Karoline. "No further questions," she said. And just like that, the moment was sealed, not in victory, but in validation. Not everyone agreed with her, but nobody doubted her anymore. But outside these walls, something much bigger was already brewing, because one clip, one sentence, had just started spreading far beyond the hearing room. By the time Karoline stepped out into the overcast Washington afternoon, her phone was vibrating nonstop. She ignored it for now. The steps of the Dirksen building were crowded with reporters, but she didn't stop to speak. Not yet. She needed air. Down the block, across from a parked security SUV, she leaned against a bench and finally checked her screen. 3 missed calls from her old campaign manager, 12 unread texts from friends, some she hadn't spoken to in months, and a video link. She tapped it, a 37-second clip already labeled, "Young woman silences Justice Barrett with one sentence." In the thumbnail, Karoline's mouth was frozen mid-sentence, her brow tight with focus. She hit play. The clip showed her exchange about dignity. The line that echoed, "Privacy isn't just a legal theory, it's a part of dignity, of being human." The comments below were already pouring in. "I don't even agree with her politics, but that was surgical. This is the kind of person we need on the bench in 10 years. Why do I feel like I just watched history shift slightly?" A lump rose in her throat. Not from pride, from the sudden awareness that the private moment she had prepared for, agonized over in silence, was now out in the world, raw and exposed. At that moment, her phone buzzed again. An unknown number. She hesitated, then answered. "Karoline Leavitt." The voice was low, clear, professional. "Miss Leavitt, this is Melanie Brooke from 60 Minutes. We'd like to talk with you about a feature on young voices redefining American law." She didn't respond right away. Her mind flashed to 100 things. Her childhood in Atkinson, New Hampshire, the debate stage where she fumbled a response and got laughed off Twitter, the nights she stayed up reading old case law with highlighters and cheap coffee. "You still there?" the woman asked. "I am," Karoline said. "But can I call you back?" "Of course." She hung up and stared at the sidewalk. There was something unreal about it all, not because it was too big, but because she had imagined it so many times before. That hearing room, that pressure, that moment of being underestimated and deciding, no, not today. Across the plaza, a group of interns huddled around a phone. One of them pointed at her. Another mouthed something, she couldn't hear what. But they weren't laughing. They were locked in. In some parts of the country, the clip was already playing on local news. In others, talk radio was debating whether she had just embarrassed a sitting Supreme Court justice or simply raised the bar for civic participation. Online, battle lines were forming. Some called her dangerous. Others called her brilliant. The truth was probably both, and neither. Inside the committee chamber, staffers were still filing out. Justice Barrett hadn't made any further comments. She slipped out through the side entrance, shielded from the press. But what she didn't say had already said enough. That nod, barely noticeable, was being dissected frame by frame online. Was it respect? Was it surrender? Karoline knew it didn't matter. It was proof of something bigger. This wasn't about Barrett, or about her, or even about the Constitution. It was about a culture that had started believing youth meant ignorance, that being young and loud meant you had nothing to say. And Karoline, whether people liked her or not, had forced a room full of legal giants to stop talking and start listening. But one question was still lingering, one that no clip could answer and no headline could explain. Later that night, Karoline sat alone in a small hotel room in Arlington. The suite wasn't fancy, just quiet. The kind of place that didn't pretend to be more than it was. A leather-bound folder with the Jeffersons stamped in gold sat on the desk, unopened. The television was off. Her phone was finally charging across the room, silenced. Outside, rain tapped lightly against the window. Inside, she stared at a yellow legal pad, half filled with scribbles from the day before. Notes she didn't need. Arguments she didn't use. A reminder to breathe written in the corner. She hadn't expected it to go viral. That wasn't the point. She didn't walk into that hearing to prove anything to the internet. She walked in because somewhere along the line, she realized she couldn't wait for someone else to say what needed to be said. She got up, poured some tap water into a plastic cup, and sat by the window. Her reflection in the glass looked calm, but her hands still trembled slightly. Not from nerves, from the aftershock, holding it all in, only now letting it land. Her phone buzzed again. She didn't move. She was thinking about what Barrett had asked. Why come here? Why now? Karoline had known that answer long before the invitation came. It wasn't about ambition. It wasn't about going viral or catching headlines. It was about standing up in a room that wasn't built for her and refusing to shrink. Because too often, voices like hers were told to wait. Wait until you have more experience. Wait until someone else says it first. Wait until you've paid your dues. But rights aren't inherited with age, and truth doesn't need to ask permission. A knock at the door interrupted her thoughts. She hesitated, then opened it. A hotel staffer stood holding a manila envelope. "This came for you," he said. "No return address." She thanked him, shut the door, and opened it slowly. Inside was a single piece of paper, typed, no signature. I don't often find myself surprised in a room like that, but today I was. Stay sharp. The country needs voices that aren't afraid to speak plainly. She read it twice. There was no name, but she knew who it was from. She folded the paper, slid it into the front pocket of her folder, and let out a slow breath. No applause, no cameras, just a message that mattered. Tomorrow, she'd go back to being polarizing. Some would accuse her of being reckless. Others would try to turn her into a symbol. She didn't want either. She just wanted people to remember the law wasn't supposed to be an exclusive club. It was supposed to be a tool, one that worked for the quiet kid, the underdog, the people who can't afford lawyers, but still know when something feels wrong. Karoline took the legal pad, flipped to the back page, and wrote something in all caps. The law doesn't belong to the powerful. It belongs to the prepared. Then she underlined it, twice. It wasn't a line for the cameras. It was a reminder, for herself. Because one day, someone younger than her would walk into a room full of critics, scared and underestimated, and wonder if they should just stay quiet. And maybe, just maybe, they'd remember her name and speak anyway. Because moments like today don't change the world by themselves, but they do remind us who it belongs to. Moral of the story? You don't need permission to be heard. You just need to be ready. If this moved you, if you believe voices like this matter, subscribe. There's more coming.